there are, name it, the whole of Uganda are in for a treat with Tiki Choma. What can you tell me more about this? Because I've preached this gospel so many times that this place is a gem. It is something very unique that is unheard of. The service is top notch. What can they expect when they come here?
Now, Tiki Choma gives you a great ambience. There is good customer service, and above all, the best food available in town.
Live from UBC Studios in Kampala, this is Good Morning Uganda Extra.
Good morning, Uganda. This is Good Morning Uganda Extra. My name is Julie F. Nantava, and I'm sitting in for Robert Chirabo Nyonyintono. Now, one thing for sure is that at some point in this lifetime, we all lose a loved one. And many a times when we lose these loved ones comes drama with it sometimes, especially in matters regarding their estate and property, especially if they have not left a will behind. So that's why this morning we are having a conversation on with the Judicial Service Commission and really its mandate and interstate succession. I am slowly learning how to pronounce this particular word, interstate, because it's very easy to just mispronounce it as interstate, but it's intestate. And I'm not here to learn it on my own. I am here with Patra Alinda, a legal officer at Judicial Service Commission. Now, be a part of the conversation. 0709-602-592 is the WhatsApp number that you should save and ask those questions, because I know they are there. My name is Julie F. Nantaba, and thank you so much for watching UBC TV. We come to you live from Nile Avenue, and this is Good Morning Uganda Extra. Good morning, Patra Alinda.
Good morning, Julie. Thank you for having me today.
Right.
I'm honored to be here, and I'm already feeling at home.
Glad you are feeling at home and ready to inspire Ugandans on this very, very pertinent issue. Let's start off with what the Judicial Service Commission is and a detail into its establishment.
All right. So Judicial Service Commission is an institution established by the Supreme Law of the land, which is the 1995 Constitution as amended under Article 146. The Judicial Service Commission has its specific mandate. What do? We advise the President in the exercise of his powers on the appointment of judicial officers, right from the Chief Justice until the Principal Judge and the Chief Registrar. But we also appoint persons as Chief Magistrates and also Magistrate Grade 1s. We also appoint persons as staff in the judiciary. We are talking about process servers, we're talking about court clerks, we're also talking about office supervisors, everyone that works in the judiciary as staff. We also exercise disciplinary control over these people that are in the judiciary service. Most people think that people in the judiciary do not have
untouchables.
Untouchables, exactly. But Judicial Service Commission exercises disciplinary control over the persons in the judiciary service. But most importantly, we have a mandate under the Constitution to prepare and implement programs for the education of the public about law and administration of justice. And that is why I am here today, to be able to teach the public about law and administration of justice. And like you said earlier, I will be looking at succession law because it is something that is pertinent to everyone. For as long as you're a human being, you'll either lose someone or unfortunately you'll be the one to go, and your estate may be managed or distributed in the wrong way, or if you have knowledge about the law, you can prepare your family to be able to handle your estate and manage it and distribute it in the right way after you have passed on. So today morning we'll be here to teach. I hope that the public will engage with us and learn one or two things.
Indeed. The goal is to learn a thing or two for you to be inspired. So keep those questions coming in, 0709-602-592. Now, just to stay with the establishment of this commission, the Judicial Service Commission, who sits on this commission and who selects the people who sit on this commission?
Okay, so who sits on the commission of the Judicial Service Commission? We have the chairperson of the Judicial Service Commission, who must be of the same rank as the judge of the High Court, appointed by the president. We have the deputy chairperson. Then we have 2 representatives from the public who actually help us to become a bridge between the public and justice. And then we have justice from the Supreme Court. We have the Attorney General, who is an ex-officio member of the Judicial Service Commission. But we also have 2 advocates who are senior advocates or senior counsel who sit on this commission. So those are the people, and the secretary to the commission, who we usually refer to as the permanent secretary for administrative purposes. So those are the people that govern or run the commission. Yes.
And who selects these individuals, especially now, I think for the 2 people who represent the public, who bridge the gap between the judiciary and the public? Who selects this public? Is it us? Generally, each individual who sits on that commission, who are they selected by?
They are selected by Public Service Commission and appointed by the advice from the Public Service Commission and appointed by the president. So with the ones representing Uganda Law Society. So the public is represented from all angles, even from the legal perspective, but even the public that has nothing to do with law, that they can also be appointed by the president.
And one would wonder if this person, especially those who are representative of the public, it's quite interesting. Do they have to have knowledge of the law? Do they have to have a background of the law? Especially that other one who represents the public with no law whatsoever. In one way or the other, do they have to have done something to earn their seat at that commission?
No, they shouldn't have. They don't have to have studied law, because already we have the legal part represented. But we also want to be able to, how do we reach to the people? How do we be able to implement programs to the people? We need someone from the public who's going to give us an eye and say, while you have these legal education programs, why don't we simplify them? So it's them that they'll give us this eye, and we'll be able to prepare and implement programs. So they don't have to have a legal background or anything, but as long as they're from the public. In fact, they're from the public and they do not have any legal connotation to them. So that makes them eligible.
All right.
Yes.
Now allow me stay there so that we take out all the necessary juices. Still, this person representing the public, can it be me? Can it be a random choice? How do they get to that point of being a representative of the public?
They can, even you can be, for as long as you've not been a criminal at any one point. I think that's the most important thing. You've never been a criminal, you can always be appointed to represent the public on the Judicial Service Commission. So if you have had any criminal record, we will not be able to have you appointed. The president may not appoint you, but if you have no criminal record, you can always be appointed. Even you right now, you could leave this studio and tomorrow you're the person representing the public on the Judicial Service Commission. 50
million Ugandans. How is he able to seek out one human being to be part of the public that represents Ugandans and their views?
The president has his powers. That one is upon his discretion, really.
Yes.
So that one you cannot ask how he does it, but he does appoint. And actually, they are 2. It's not just one.
Yes.
They
now the other one has has a legal background, right?
No.
And then
both of them from the public, they don't have the legal background.
Both.
Yes.
Very interesting. What a way to be involved as a Ugandan in matters that concern us. Now, one of the hardest conversations when we lose loved ones, or not just loss, but the conversation of succession. It's usually complicated right from family even to areas and platforms of governance. It's always very complicated. First and foremost, what is succession?
Okay, so succession is the legal process by which property of a deceased, someone who has died, is managed or distributed. Now we have succession laws in Uganda. They can be managed by tested succession, where a person has a will. They can be managed by intestate succession, where there is no will. And we know that majority of Ugandans, we fear writing wills. We think that when we prepare wills, we are going to die the next day.
We are jinxing ourselves.
So 70% of us actually die intestate. But succession is the legal process through which your property is transferred from you to your beneficiaries, either through a will, that is referred to as tested succession, or alternatively, intestate succession where you have died, and in such circumstances, then the law takes place, takes effect. So we implement the succession laws as amended to distribute and manage your property upon your death.
Interesting. Now, in just a bit, you explain what intestate succession means, because it's a word that is featuring in this conversation, but be part of it. You've lost a loved one. You are in the middle of chaos in regards to the estate of that loved one, or you are not yet passed yourself, but you need to prepare for your loved ones. 0709 602592. It's the WhatsApp number that you should save by and engage by text WhatsApp, so that you're able to be part of this conversation. This is Good Morning Uganda Extra. My name is Julie F. Nantaba, and I'm having a conversation with Patra Alinda, who is a legal officer at the Judicial Service Commission. So what is intestate succession?
Intestate succession is where someone dies without a will. You pass on, you have no will. So intestate succession, when you pass on and you have no will, they say he died or she died intestate. Now, intestate succession, like I earlier said, succession is the legal process by which your estate is transferred from you to the beneficiaries. So intestate succession, in the simplest terms, is you've died without a will, so your property is managed and distributed according to the succession laws, instead of according to your wishes. When you die with a will, we respect your wishes, because you gave us your last wishes. You said, I want my property to be distributed like this. We shall respect that. But when you die without preparing a will or leaving a will behind, that means your property will be distributed according to the succession laws as amended. And the succession laws have actually been amended. The recent amendment was in 2022 to modify and promote things like equality. Originally, we did not have equality when someone died without a will. Some of the things were taken to probably the male, but now we have incorporation of both male and female. So when you die without a will, your property will be distributed according to succession laws, and that is what is referred to as intestate succession, with other modifications in the succession laws. So now we'll look at the succession laws as modified in 2022 to govern your property and have it distributed to the next people who are the beneficiaries.
Now, when you talk about someone passing on without a will, but they had wishes, let's first look at what that will should look like. Must it be a written will, or an audio note, an audio will, or perhaps they shared with someone that I'd like ABCD to be given to ABC and no one should touch ABC, just by word of mouth. What does the law approve as a will?
So a will must be written, for sure, except for soldiers who are on the front line of the battle. Those ones, they can give an oral will and it will be implemented. But for every other person, you must be 18 years and above. You must be of sound mind at the time you made the will. Most people make their loved ones make wills when they're on the deathbed. Are they in their right mental capacity when they were making that will? So if it's proved, or if other people say, I don't think this person had the capacity to make the will, then that will be revoked. So your will must, we don't dictate what must be in a will, but there are two things that must not be there. Your residential property must not be distributed. If, for example, I have our home, I should not distribute it to our last child. It should be protected for the surviving spouse and the children who are going to be who were in that residential home at the time you passed on.
Right.
But everything else, all your land, all your cows, all your hens, you can put in your will. For as long as you're 18 years and above, you have sound mind, you're in your you're in your upright mental capacity. But even those that have mental instability moments, at the time you were mentally okay, you can make a will. So what must be in this will? The people that you want this property to be distributed to. What is this property? This property must belong to you. You cannot distribute in your will property that belongs to someone else. So it must belong to you. And you must appoint an executor who is going to help you distribute this property. Actually, we've seen cases where most people prepare wills, but they forget to include who is going to help them execute. They say, I have this land, this one should go to this child, this one should go to this child, but then they forget to put who is going to help you transfer this property from your names to this child's name, who is an executor. And there is a recent amendment that even this will must be signed by at least 2 witnesses, and on each page. So if you have a 2-paged will, every page must have, if I'm a witness to your will, I must sign and write my name on each page. The pages that are not signed and written by me and another witness, then they will not be considered as valid. So all the pages from page 1 up to the last page. But also we must sign after you have signed. So you as the testator, now you see we said intestate for where there is no will. But where there is a will, you died testate. Yes, you died testate. So we respect the wishes. We respect all the wishes that you put in your will, as long as it is within what I have just given. You can make it as simple. You don't have to have a lawyer. You can make it in the simplest English. You can even write it in the other language, and they'll always convert it to English. And you can always keep it with your lawyer, with your close friend, with your bank, with a magistrate, with the courts of law, and it will only come into effect upon your death.
You've talked about you as someone who's writing this will, assigning someone to help in the distribution as by your will. Who is this someone?
This someone is picked by you. You can pick anyone. That's why we say when you die with a will, your wishes, you can choose anyone. You can choose your brother, you can choose your wife or your husband. You can choose, most definitely would not want you to choose a beneficiary, because if I'm already a beneficiary like a spouse, then I shouldn't.
Because a wife and a husband.
Yes.
Well, brother maybe, but a wife and husband clearly.
Yes, so a wife, husband, you shouldn't be the one witnessing. And remember, there are 2. There should be 2 or more. There can be 10 people witnessing your will, but the list should be 2. So at least it can be your brother and your close friend, your brother and your employer. If you have a good work relationship with your employer, it can be anyone. Your brother and your lawyer, your sister and your lawyer, your sister and the courts of law. So it can be anyone except the beneficiaries for whom this will has been prepared for.
Oh, so that means you can actually even choose a lawyer.
Yes. Most people choose lawyers to be able to do it for them.
I think that's a balanced one. 0709602592. It's a WhatsApp number. Be able to text to that WhatsApp and ask your questions. In this life, we live, work, make the money, make, have all these properties that are available. But the reality is we all come to pass. And properties are left behind, to whom many a times it's chaotic, especially for family members. You do not want your family to be the ones killing themselves over things that maybe they never even woke up for in the early mornings to work for like you did. You want them to have a peaceful life as they enjoy the works of your sweat. And that's why we have Patra Alinda. She is a legal officer at the Judicial Service Commission. And she's teaching us about the mandate, first and foremost, of the Judicial Service Commission, but also matters interstate succession. Once again, 0709602592. Now, we've looked at what interstate succession is, but for matters of understanding the vocabulary that works around these matters, who is an intestate when we call them interstate? who are we referring to as opposed to intestate succession, as we've just learned?
So who an intestate is? Someone who has died without a will.
And intestate succession is
Yes.
dying without
Yes. So
a
the
will.
moment you pass on and you had no will, the first thing they say is he died intestate when it comes to management and distribution of your property. He or she died intestate. So you are intestate. Just like I said, testate is you died with a will. He or she died testate. He or she died intestate. They died without having a will in place.
Right. Now, because family is family, in one way or the other, all of us are surrounded by these stories. You hear these stories in one way or the other, directly or indirectly. And there is one word I've heard from, I think, as far as childhood, and that is administrator. 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 This administrator was removed, and now they gave us another administrator. Who is an administrator of an estate?
An administrator of an estate is someone who has been appointed by the courts of law and granted letters of administration to distribute the property of the deceased to the rightful beneficiaries. When you have died without a will, you did not express your wishes for who will help you transfer your property to your beneficiaries.
Right.
So the courts of law require that within the family, choose someone who is going to help the family transfer, bring order. In short, an administrator is someone who should bring order upon the death of upon the death of someone in the family.
Kindly allow me interject. When we have a tested, one who has passed on tested, and they've chosen who should distribute, are they also called an administrator?
They are called an executor.
Oh, interesting.
Yes.
Because they know their role.
They
who's
know
supposed
their
to
role.
do what's supposed to go where.
Yes.
And administrator is not in the capability of distributing what,
Yes.
but just to manage.
Yes. Now, the administrator will be guided by the laws.
Right.
I know people are going to say, but usually we have a will, but then they give us an administrator. In such circumstances, that means the will had no executor. Where the will had no executor, you also apply to court, and then an administrator comes into place. This administrator must be appointed by the family with the consent of the beneficiaries, and then they go to court. Upon going to court, they are granted letters of administration after a long procedure that we will later see. It's not as easy because we know that there are people who may not have good intentions for the beneficiaries.
Yes.
So there are checks here and there. Were you given consent? Do you have a certificate of no objection? Have the beneficiaries allowed you to actually transfer this estate, manage it, and distribute it to them? So that is an administrator. And an administrator, by the way, does not own this property, does not become the owner of this estate. Other people have a challenge. When you become an administrator, you take on this property and it belongs to you. That is wrong. It is intermeddling, and you can be sued and even be imprisoned. So an administrator, your role is to manage and distribute the estate. There are other roles. For example, once you're given the letters of administration, you must file an inventory with court to keep court updated. Whether did you actually distribute this property? How are you managing it? And in case you have, because you should distribute it in 1 year. But we know for a fact in Uganda that administrators can even manage property for 20 years.
True.
Which is not supposed to be so. So you're supposed to file an inventory with court and give them an update. How are you distributing? If it's property that has in minors, they should allow that time. But if the property is for beneficiaries who are above 18, there is no reason why you should hold on to this property. So you're not actually the owner. You do not become now the owner of this property.
Like many do.
Like many do. And that's why we do these sensitizations.
Yes.
So that people know that an administrator is just to manage and distribute property to the actual beneficiaries as in the laws of Uganda. But they are not the owners. But we've seen them. An administrator gets letters of administration, and the next thing they do, they transfer the property into their names.
That's true.
And they become the owners of this property. And the actual beneficiaries now start to have fights here and there. with the administrator, and even find the children of an administrator now even become the ones that are enjoying this property instead of the actual beneficiaries, who are the children or the surviving spouse. So that is why we have such sensitization, so that we remind people of their legal roles.
Indeed. Indeed, these moments of sensitization are very key. 0709-602-592. Share your opinion or your question so that you are well educated and given the knowledge that you deserve. Knowledge is power. And when you have that power, you are able to escape and skip a few hurdles here and there of life, especially with matters the law. We are looking at the mandate of the Judicial Service Commission and interstate succession. You've talked about an administrator having to usually handle these things for a year, except in cases of minors, but many a times even for non-minors, it stretches to years and years.
Yes.
Why does it happen like that?
I think it happens because people are not aware of the laws. The beneficiaries are not aware of their rights and obligations in regard to this estate, and so are the administrators. Someone passes on and then they say, this one, let them be an administrator, because maybe they are the ones that are available,
right?
And then they go and get the letters of administration and they don't know what next to do, and then they, or because of the greed or because of so many things, and they end up having this property. But this property should be distributed to the beneficiaries. Who are the beneficiaries actually? I've been saying beneficiaries, but who are the beneficiaries? If a person has passed away, the actual beneficiary is recognized by the laws. We have the surviving spouse. The surviving spouse is someone who is legally married. He or she, your husband or wife, is a surviving spouse, and you must be legally married according to the 7 recognized marriages in Uganda. I won't go so much into them, but we know most of them. Customary, civil, church, Islam, and others. 2, lineal dependents. Who are the lineal dependents? The children of this person, the children of the man or woman, irrespective of whether these children belong to the wedded wife. Even children from other are beneficiaries to the estate of the deceased. Let it be, of course, Uganda being a patriarchal system, we know that mostly it will be to the man. Most times women, that's why the Succession Act has come in to solve these loopholes. Yes. But originally we believe that these succession things were for only men. So the surviving spouse, someone would think it's only a woman. And then they would say, okay, me, I'm the wife, but these children are not for me, so these children are not beneficiaries to the estate. They are beneficiaries to the estate. And then dependents. At the time of your death, in Uganda we have a system where you find at the time of your death you are supporting other people around. They are not necessarily your children, but they were there. So if they were solely dependent on you for life's necessities, for example, you had these other children, maybe you were educating them, they are also beneficiaries to your estate. And then lastly, we have a customary heir or heiress. We now have an heiress according to the Succession Amendment Act of 2022. So they are also beneficiaries because we are from a background where we have our culture norms. So we recognize that different homes have different settings. So if you have a customary heir or heiress, they also are beneficiaries to the estate. So those are the beneficiaries as recognized by the law.
Right. Some of the comments coming through. Thank you so much for watching. Good morning, Uganda. First, please put up the number on the screen to be copied. You are too fast when you read it. I do apologize. 0709-602-592. I hope it's also displayed on your screen, but I do apologize on that. And also the big words coming up, write them on the screen. We may not understand your pronunciation, as we also want to know how these words are spelled. And the big words so far I think that we've used are interstate succession and interstate, basically. I do hope the producer is able to display them on your screen so that you're able to see what it looks like. But just to spell it for you, interstate is I-N-T-E-S-T-A-T-E. I-N-T-E-S-T-A-T-E. intestate. And then succession, as you might very well know it. Now, let's look at what a letter of administration is. We hear that word quite a lot. It's very prevalent. But what exactly is it and what is it about?
So a letter of administration gives you power to manage and distribute property. Again, we have a challenge with Ugandans. When someone has passed on, people are quick to distribute property without a letter of administration. That is also an offense according to the law. You must have a letter of administration, or letters of administration, as they are termed actually. So, before you get letters of administration, these are awarded by courts. You must go through a process to obtain them. You don't wake up in the morning and you have these letters of administration. So this person has passed on. They have an estate. An estate, we are saying this is property. It can be movable and immovable. When people say estate, they are only thinking about acres of land. Even your border is an estate because it belongs to you. Even your pension, even your NSSF savings are an estate. Your houses are an estate. Rentals, they are an estate. So all these things except your salary. Your salary is not, your salary does not amount to your estate.
Now what if life happens and I pass on in the middle of the month, but I've been working? And at the end of the month, of course, the systems know that they have to send that money to the bank.
They'll give you benefits for only that month.
Right.
Yes. After that, makes sense, yes. Yeah. After that, it's not an estate that can be managed and distributed. Yes. It's not an estate. It's not something that can be continued. So you've passed on. You have this estate, like I've just simply given us a picture of what an estate is, so that people don't think, oh my goodness, how about us who don't have acres of land? No. For as long as you're 18 years above, you have your phone. It can be transferred. It can be your estate. It can be your estate. Right. Yes. So, so you have all this. But you've died without a will. So your family members should be able, first of all, to obtain a death certificate. A death certificate is very easy to obtain from NERA. All you have to do is attach a postmortem report or a medical report from the hospital showing the cause of death, or if this person's died from home, an LC letter confirming that actually this person passed on. Then you must have your national ID, you the applicant, and the national ID for the deceased. You attach them, you fill in a form with NERA called the death notification form. You submit them to NERA, you pay some fees, you attach that receipt, and they'll give you a death certificate. You've obtained your death certificate as a family. You hold a family meeting as a family. The people that are close to the person who just died without having a will, but there is a whole estate to be managed and distributed. Right. So you hold and say, okay, who should we appoint as an administrator? Who is going to help us? This is what should happen. But actually what happens in Uganda, after getting a death certificate, people go on to divide and put lanes. Now this land belongs to me, this one belongs to this person. That is wrong. You should now sit as a family and say, who are we going to appoint as an administrator to help us have the law come into place? Now this administrator appointed by the family should go to the Administrator General's office. In other districts, you can go to the CAO, Chief Administrative Officer. Right. And from there, they'll help you fill in a form where you are supposed to give a report of what was the estate of this person, or the properties as ascertainable, the properties that you actually know. And then you're supposed to tell us, did this person actually have a will? Or, you know, usually when people die, they say, there's a will, but we don't know why it is. They say to have said a will, so you can give us all that information. Did this person have a surviving spouse, for both a man or a woman? Because these days we also have women who have property. Yes. Then you can, you have to attach the surviving children and the ages. You must tell us what's the age of each surviving children. Did this person have dependents? Is there a customary heir? Once you submit all those things to the Administrator General, then they will look through this file and then they arrange for a meeting, them with the family. Now, please continue. I was going to ask about the letter, but first I'll drive that home. Yes. So now we're in the process of getting these letters of administration. They don't. That's what I'm trying to say. You've gotten your death certificate. You've held a meeting, appointed an administrator. This administrator has gone to the Administrator General's office, obtained a file, filled in all this information for them. Then the Administrator General sends either a town clerk or they send a lawyer to come and have a meeting with you where you must extract minutes. They ask, was there a will? Who have you appointed you as a family? Who are the children? We need to inform people that all the children are beneficiaries, whether children born in the marriage and outside the marriage. It's not their problem,
right,
that they were born outside. So after all those things, they also ask for, they ask for consent from the beneficiaries, that they consent. Are you consenting that this person you've appointed and as administrator, you actually confirm that you are the ones who it's out of duress? Because an administrator is a very key position. They can misuse the property. So the beneficiaries must consent. Usually the surviving spouse is given a certificate of no objection as an administrator. But where we have polygamous families and there are issues here and there, they can always choose another administrator. And administrators can be 1, they can be 2, and the most they can be are 5. That's required to the law. So once you have all these things in place, now you go to the court. Court is dependent on the value. Is this estate worth 50 million and above? Then you go to the High Court in the area where the property is located. If the property was located in Masaka, we will go to the High Court of Masaka. If it was in Kotido, we will go to the High Court nearest. Then if it is below 50 million, within 20 million, can go to the Chief Magistrate's Court. And if it's below 20 million, you have only your 3 motorcycles, you can go to the Magistrate, Grade 1. And upon there, that's where most people, we advise that if you can have a lawyer, because you have to draft documents which include the petition, which include the declaration, they must be verified by the Commissioner for Oaths, your application, all these things. We advise that you have a lawyer at this point as a family so that they can guide you. Now, after you've submitted all these documents to court, then court will review them and ask you to submit information in the local newspaper. We see most times, if you see behind, you'll see people advertising for obtaining letters of administration because it's law, it's required that you don't administer estate. Some people administer estates when the person is still alive.
Wow.
Yes, so that's why we have all these stringent laws here and there. There must be an identification by the magistrate to identify you that you're actually the one that has been appointed. So after going through all that process, it may not take it won't take 1 week, it may not take 1 month, it may take some time.
Right.
After the courts have been sure that actually you're the administrator, then they will give you letters of administration. Now these letters of administration are for only 2 years. According to the recent amendments, they can expire because the courts of law realize that people hold letters of administration for 20 years. They neither manage the property, they neither distribute the property, they misuse the property to their advantage, and the beneficiaries are left with nothing. So that is why there's been a new amendment that these letters of administration expire after 2 years, except where you're holding an estate in relation to minors or in relation to pension. But even pension, there is a time frame within which they expire.
What's the time frame for pension?
So pension, we estimate 15 years. So if you had already started, if you had taken off 2 years, we'll deduct 2 years and see, okay, how many years were remaining for this person, and that is it.
Now, let me engage some of the comments. Thank you so much for watching the show and engaging. Good morning, UBC TV. This is Irene Akelo from Gulu City. Can you just enlighten more about the distribution law, of the law of distribution in case of a person who died intestate? Please speak into it.
All right. So the distribution law where a person dies intestate, the general is that the children will get 75%. The wife will get, the surviving spouse, the surviving spouse who can be a wife or husband, according to the new amendment, will get 20%. And then the dependents, if they are any, will get the other remaining. The customary heir gets 1%. That means the dependents may get about 10 or 15%. But then there are other distribution laws where there are no children. The surviving spouse gets 99 and the customary heir gets 1. where there is only a surviving spouse, they had no children, they have dependent relatives, the surviving spouse gets 50, the dependents get 45, and the customary heir gets 1.
The customary heir, what if they're
Or heirs.
Your heirs? I believe many a times, many as the case might have it, they are also children of the deceased.
Yes.
So they are part of the 1% for being the heir or heiress, and then the other 45, is it 45? For children?
75.
75 for children.
Yes.
There are separate dockets and offices for them.
Yes.
1 in 2.
Yes.
Interesting.
Yes.
Good morning, UBC. The law will always amuse you. Good morning, UBC. What is required to extend letters of administration in case they have expired in regard to the current law? This is Silva Wamala in Masaka. And he also adds and says, if I'm appointed an administrator to a late or deceased who didn't bear children, what happens to the estates? Those are the two. So the first one is what is required to extend letters of administration in case they have expired in regard to the current law. And I believe they are referring to the amended Act as of 2022.
Yes. So what is required? One, you must, first of all, give reason why you did not distribute. You must have valid reason,
Right.
either because this estate is, the beneficiaries are mainly minor, or pension, or you give an inventory and say we are distributing, but so far this property is the only one remaining. So there must be a valid reason, and secondly, there must be consent from the beneficiary saying, okay, let's give this person a second chance. Other than that, if the beneficiary say no, we don't want this person as our administrator, we've had 2 years of headache with him or her,
Right.
then they will reject the renewal. So there must be valid reason, and usually they are 2, and then the consent of the beneficiaries. Then the second question is if the person you are an administrator, the person had no children, but they had a surviving spouse.
What happens to the estate?
So the estate goes to the surviving spouse and the customary heir or heiress. The surviving spouse gets 99%, and the customary heir or heiress, who may be the brother or the sister to the deceased, gets 1%. You, the administrator, you do not, the estate is not yours because this person had no children.
Right.
I hope that person is not looking at it from that point of.
Very interesting, but I hope you've been corrected and your questions have been answered. Finally, someone comes through with quite a plethora of questions. Hopefully we are able to answer them in the remaining few minutes that are left. Good morning, Judicial Service Commission and UBC. Aye David from Lira. I would like to inquire about how many times should a person make a will?
That's an interesting question.
Very.
I like it. You can make a will as many times as you want.
Make, destroy, make another, destroy, make
Yeah,
another.
yes, but the will that will be recognized upon the death of the person is the latest will.
Right.
Actually, I have a close relative who made about 4 wills. They made, after 2 years, there's another one, and then at the time of the death, they considered the last. All these were there, and they could see them, and there were changes. For example, you make a will today, and 2 years later, you have more property. Or 2 years later, you have more children. You had only distributed 2 children. Now you have 4 children. You hadn't included these 2 children. So it's advisable that you make as many wills as you can. And usually they are called codicils, these other attachments. But at the last, upon your death, the last will is what is considered.
All right. Again, can a will be amended by the administrator?
No, the will cannot be amended because the will expresses the intentions of the deceased. So the moment a person dies, it comes into effect. So it cannot be amended.
Right. The third one, does the letter of administration have an expiry date? Yes, she has talked about that.
Yes, 2 years.
2 years, indeed. Fourth, is it proper to stop or call null and void on the selling of properties by a person who is not authorized by a will or letter of administration?
Yes, it is. Actually, it's an offense, and once they bring a matter before court, you can even be imprisoned for 10 years.
Right.
Yes.
And lastly, what if a deceased makes his or her own will granted to a person below 18 years old, leaving the elders? What should be done?
In such circumstances, the will is to the person below 18, but they are elders. The elders are the executors, so they help manage this estate as this person turns 18, and upon this person turns 18, then they will distribute the estate to the person.
Right. Now, this conversation has to come to its end, but we can't close it, Alinda, without talking about offences and penalties. So take us through offences and penalties as to these offences as we begin to close, and of course your parting shots.
All right, so the first is intermeddling, which most people do. You have no letters of administration, you're distributing an estate. It is an offense under the law, and you can be punished until 10 years of imprisonment. Misuse of an estate of a deceased. You're an administrator, you've been granted letters of administration. Instead of distributing this estate, you are actually having this estate transferred from the deceased name to your names. You can be imprisoned for 7 years. There is also theft. Some people do steal. There is also an offense where you actually distribute without the consent of the beneficiaries. You can be imprisoned. All these things, they seem so simple.
Light, yes.
They seem so light, but the repercussions are actually big. And my parting shots are, we hope that people have learned. We continue to prepare and implement programs as Judicial Service Commission for the education of the citizens. And in case you need us, you can call us on our toll-free lines, 0800 100 221. 0800 100 221. Feel free to call us at any time from Monday to Friday, 8 a.m. to 5 p.m. and we'll give you legal advice, because it is our mandate to advise and give legal knowledge. We cannot represent you in courts of law, but we'll give you legal information in matters in relation to law and administration of justice. I hope that today we had a good session. From the questions, I impressed that at least people were following. And thank you, UBC, for giving us this opportunity to be able to educate the masses about law and administration of justice.
Indeed, and we do hope to have you back, because matters law will always be extreme and elaborate, and there's always knowledge to garner from on there. Thank you so much for watching Good Morning Uganda Extra. That's been Patra Alinda, a legal officer at the Judicial Service Commission. And we've been looking into the mandate of the Judicial Service Commission and also interstate succession. Usually, really, that's the word that we've been playing around with, of course, letter of administration, which is quite unknown, but intestate or testate is the two words we've been playing around with for our friend who came through and said we're using big words. And really, it's about writing wills, leaving wills, and how all of this is managed as by the law, and of course the amended act as of 2022. Thank you so much for being on the show. Good Morning Uganda ends here, but we'll be back on Monday. Good Morning Uganda from 6:30 into 9, and of course Good Morning Uganda Extra. Keep it UBC TV, keep inspired. Good morning.
Live from UBC Studios in Kampala, this is Good Morning Uganda Extra.
Teens Proud, an amazing off-the-hook